Streaming's on.
Huh?
Streaming's on.
Ready?
Sorry, I didn't give you the front row. So difficult.
So you have a million things in your head when you start. I know. No problem at all.
In other courts, they've got a seat principle there. They do a diamond.
Well, guys.
Yes, Mr. Brown, I think I cut you off in full flow from answering one of my lady's questions.
Lord, I'm grateful. I'm going to deal now with the grounds head on. I'll deal first with ground 5, if I may, and then inconsistent judgments, and then I'll deal with the specific challenges to the specific findings of contempt. My lady, where I'd like to take the court first is in the continuation sheet to the contempt application, which sets out the allegations of contempt. And that's behind tab 10 in the core bundle. And if the court could please turn up page 267.
Are we going to get this affidavit?
We can get hold of it. I want to give the context. This affidavit was required to be produced under order of Mrs. Justice Fogg. And you'll see in paragraph 14, it refers to the affidavit and says that Mr. Varma made the following statements, giving the following answers to the following questions, which were questions posed by the joint liquidators. And over the page, you'll see at 14.2, the pertinent question in relation to the falsehood that was subsequently alleged, my lady. When the company paid circa 3.1 million into the account of Grosvenor Consultants FZE, what happened to these funds after that? Answer 5. The funds were paid against sale of jewellery and diamonds to the company. Grosvenor Consultants FZE used some of the money to meet its financial obligations and debts. Some of the money was used towards expenses and some of the money was used towards failed and abortive transactions in Dubai, UAE. Details of the above are in Dubai, and I can only access them when I go to the UAE and can provide you with the same. And you'll have seen in the judgment, which makes sense to turn to now, if we go to the last page first, which is on page 64 behind tab 8. You'll see that 2 findings of contempt, that is contemptuously making a false statement, are based upon that single answer to questions. And it's findings 1 and 7 there. I'll let the court just read those. learned friend's right to acknowledge that there have been lots of inconsistencies in Mr. Varma's telling of this narrative, in particular before Mr. Justice, in particular before Andrew Hockhauser QC, sitting as a deputy judge. Mr. Varma was inconsistent on whether the gift was lifetime or whether it was legacy, whether it was from mother or father. He was inconsistent on the dates. What he has always been consistent on, my lady, is that consideration was given for the payment to him of directly to his personal account of 925,000, and in respect of the payment to GCFZE across multiple tranches, the payment of 3.1 million from the company to GCFZE. He says that that was all part of the same diamonds deal.
So he said that the 950,000 that was paid
to him directly.
to him by Grosvenor.
By the company, yes. He's described that as his share or commission on the diamonds deal. And in respect of the 3.1 million that went directly to GCFZE, he just says, well, that was part of the consideration. And it's also been part of his
commission.
case.
It's a commission of about 25%.
Yeah. And he also has been consistent on asserting that the company got a good price because the true market value of the diamonds and jewellery was 5 million. If we can just stay in the judgment for a moment, and this is why I'm trying to develop the submission. There's seductive simplicity to the submission that's put by my learned friend that this is an issue as to whether or not the diamonds and jewellery exist, the jewellery issue. You'll see the reasons that the judge gives for rejecting Mr. Varma's narrative from page 29.
Internal 29.
No, core bundle 29, bottom right.
Starts at paragraph 42.
Can I ask the court to start at 39?
39.
That's simply because that is where he sets out the understanding of Mr. Varma's case, and he refers to the judgment of Deputy ICCJ Agnello. And there's reference there, my lady, you'll see, to the 925,000. And of course, context is important here. What the judge was doing was considering Mr. Varma's case to the criminal standard. Because of course there had already been a finding by Deputy Judge Agnello that there'd been a straight misappropriation of these monies from the company, that the company received nothing for this. So in the context of the committal application, we had to prove that again, quite rightly so. And I said before the break that there were 8 reasons for his disbelieving Mr. Varma's story. I just want to make a slight caveat here. As my Lord Justice Lewison said in Phage, and I don't have it with me, I'm afraid, I think it's paragraph 115 if anyone wants to check, a judge has to give reasons, and that's really important, for example, in a context like this, so that the appellate court can do its job. And so that the right of appeal is meaningful. But all of the reasons needn't be in the judgment. The judgment can be a summary of the reasons. It doesn't have to be entirely comprehensive. I said there were 8 reasons. You'll see that 7 are listed, and it does start, my Lord, at 42. I'll try and summarise them, but I'd invite the court to read those reasons before giving judgment, because I say that whether or not the diamonds exist in the physical world is immaterial to the question of whether or not they were given to the company in exchange for money. I'll try and summarise the reasons he gives. The first is the commercial improbability. Why was a company which had as its sole purpose the development of a hotel in Bristol into student accommodation, swivelling its investment strategy and investing in diamonds from the Varma family in Dubai. Oh, well, that was Manit Singh. He was worried about cash deposits that the company had. Well, the company needed the cash deposits to purchase the hotel, which it hasn't at the time of all those payments out, which my Lord Justice Lewison was referring to from June 2017. So by this very transaction, it rendered itself completely insolvent. Was a single investor who paid a deposit trying to purchase a student flat contacted about this change of investment strategy? You can guess the answer is no. The second reason.
So the answer to this, to why the company was doing it, the answer given was not the answer that seems now to emerge, which was, well, this wasn't intended to be a commercial thing. This was actually just using the company's, albeit improperly, to effect this transfer of wealth from one generation to another for family reasons. I mean, they could have said that, but they didn't. They presented it as, Mr. Varma presented it as for a commercial reason.
Yes, exactly. So he said he advised Manit Singh, the alleged ultimate beneficial owner, to invest in Varma family diamonds because Manit Singh, he said, was concerned about the company losing money on cash deposits. And we say, well, that's completely absurd, because the company needed that money to do A, the purchase, and B, the renovations on the hotel. It doesn't help that story that there are these findings that Manit Singh doesn't exist. But we don't say that his existence has any materiality. You've been presented with evidence that a photo has been taken of someone's passport who has the name of Manit Singh. that respectfully is not evidence that Manit Singh had any involvement.
And two Companies House documents showing that Manit Singh with one address in, or one showing an address in India and one showing an address in England, has been a company director of 3 companies, not including Grosvenor.
Yes, they do. And that was common ground before His Honour George Johns. And Mr. Varma said, well, how can he not, I paraphrase again, how can he not exist when he's a director of companies at Companies House? To which the joint liquidator's response was, well, that's a matter of grave concern to the joint liquidators, given that there's no evidence of his existence. He's not responding to our inquiries about what you have said was done with company money. But the point about his existence, and I'll come on to make, I hope, a parallel point, and hopefully one that's equally persuasive about Manit Singh, is it doesn't matter one jot whether a person by the name of Manit Singh has had his photograph taken for a passport, which then been photocopied by some solicitors. Mr. Williams, by the way, received misappropriated money from the company. That's a finding of Judge Agnello, who received £42,000. So one of the things I'd be saying if this evidence had been produced in time, which it could have been, was that it ought to be treated with some caution, not that it proves anything. So that the fact of Manit Singh's existence doesn't do anything to dislodge the conclusion reached by Milady 3 judges, not just 2. Judge Agnello also made the same finding, that Manit Singh had no involvement in the company's affairs. I want to underscore something in the Prentice judgment, if I can use a shorthand without any disrespect. His finding that Manit Singh had no involvement was partly made as a result of forensic evidence. Jonathan England, who was the statutory director and the only shareholder as far as public records and Companies House were concerned of the company, had said that he took instructions on the phone from Manit Singh, which were then followed up by letters. And those letters failed the stack test. You might have seen that from the speaking report. So Jonathan England didn't turn up to give evidence for himself or anyone else at the Prentice trial or at the hearing before Judge Johns. So we say that the existence of Manit Singh is neither here nor there. It doesn't matter whether he existed. What matters is that other part of the finding, which is that he had no involvement in the company's affairs, ergo, Mr. Varma's pointing at him, saying he was giving direction as the ultimate beneficial owner, is untrue. As to, I want to dwell, if I may, on paragraph 43. This is the bit about the no real evidence of the existence of jewellery and diamonds. And can I just stop after that first sentence? I say there is no real evidence of the existence of the jewellery and diamonds. There isn't. What we have, quite extraordinarily, is a statement from Arjun Kadkar, who says, contrary to what he said before, but consistently with what he said before that he has the diamonds and jewellery. He doesn't explain why he hasn't delivered them up. Mr. Varma doesn't explain how he's suddenly been able to come back in contact with him. He doesn't even condescend to explaining why he hasn't responded to the bench warrant or the Burse order requiring him to deliver them up. He knows, we can see from his statement, that he's the second defendant of the proceedings. Good. But there's a judgment against you for millions on the basis that you admitted you have this property, whether you do or not. Can I just pause there to pick up a point made first by Lord Justice Lewison, and then a point made by Lord Justice Stuart-Smith. We did hedge our bets, that's why we used the word if. At no point did we make a positive assertion, my lord, that the diamonds exist.
Do you say that paragraph 43 is a finding that they don't?
No, I say it's a very carefully worded bit of judging, if I may. The point I want to pick up is on the back of what I've just said is that I should say our claim against Kadkar was based on admissions, not in the technical sense in the CPR, but just he'd sent us letters saying he'd got company property. So we sued him for the value he said it had, and we got a judgment. There was no part of our case that he actually had diamonds and jewellery, and I was clear about this in closing submissions. Not then I can't possibly know, unfortunately. But I said if I have to elect between my claim against the son and my claim against Mr. Kadkar, because you want to make a finding which I say is unnecessary about the existence of diamonds and jewellery, then I abandon my claim against Mr. Kadkar. But we've got this statement from Mr. Kadkar now, and I want to just turn to the next part of this paragraph, which is critical. There are not these items have certainly not been produced to the liquidators to help repay creditors. Still the case. There are not even photographs of them. Still the case. I was told that photographs have been taken of them by or for Mr. Mani Singh and Mr. Arjun Kadkar. But no such photographs have been produced. That's still the case, my lord, my lady. And Mr. Varma did not even give clear evidence that he has sought them from Mr. Singh or Mr. Kadkar, even with his liberty at stake. And then he goes on to mention other things that is what I would describe as the absence of the orthodox from the evidence. So, of course, the judge was considering what evidence he did have, but in the face of non-disclosures by Mr. Varma, a de facto director of company documents in breach of the 234 order, he also had to consider that which one would expect to see which was not there. And you might have noted from reading the judgment that those documents that Mr. Varma did disclose under the 234 order contained fabrication. In particular, the settlement and release document and the June 2017 invoice, which listed out the jewellery. So the point is now, Mr. Kadkar has come back on the scene and no one welcomes him more warmly than the joint liquidators. He doesn't condescend to tell us when he's going to come back to the UK. He doesn't say, I'm aware of the orders, so I'm going to deliver up the diamonds and jewellery. Remembering that the last thing that he said in April was that he had them in a secure location and was going to make arrangements to deliver them to the joint liquidators. Doesn't explain what he's been doing in the meantime. We have said that if, and my lady, you asked a question earlier of my own friend, Mr. McCormick QC, about this. We have said that if we recover the diamonds, credit will be given for that. So if the diamonds do exist and they're given back to us, fantastic. And that will reduce the amount that's recoverable against all of the defendants. And it will also, of course, be something that the joint liquidators, if Mr. Varma were unable to do, would have to draw to the attention of the court. Because it would go, if they were delivered up by Mr. Kadkar, said to be their custodian, it would go to whether or not they were given as consideration for the 3.1 million. And this was what I was coming to slightly before lunch when I rudely overran. There's a surreality to all of this for the joint liquidators. If Mr. Khadka has this stuff in India, Mr. Varma can contact him, which he plainly can, as he's demonstrated by putting in new evidence. Then wouldn't the easier thing, rather than appealing to this court, have been to get hold of the diamonds and jewellery, thereby proving his case? It's a reaction to a question I asked in cross-examination. Is, well, why haven't you contacted Mani Singh, and why haven't you contacted Arjun Khadka? We're suing you for millions, and now your liberty's at stake, because the joint liquidators consider they have a duty to try and force you to comply with obligations under freezing orders and such like.
You did ask Mr. Varma that?
Yes, and the judge, that's what's resulted in this paragraph here, which says, Mr. Varma did not even give clear evidence that he has sought them, that is the photographs from Mr. Singh or Mr. Khadka, even with his liberty at stake. Those were my words in cross-examination. So, moving on to the next reason. Mr. Varma, throughout the proceedings, produced various different explanations for the 925,000. We relied, and this is one of the things in the C that the court doesn't have, we relied on an email from Mr. Varma to Kennedy's, the company's solicitors, asking them to transfer the money to GCFZE, the main contractor for the development. This, by the way, my lady, before the site on which the development was to be taking place had been bought by the company.
Sorry, who were Kennedy's were solicitors?
Kennedy's are the solicitors for the company for the development.
For Grosvenor?
Precisely. Mr. Varma wrote to them and said, can you transfer £925,000?
So in this paragraph, the judge is recording three different explanations. One is it's paid as part of the diamonds and jewellery transactions. Number two is it's commission for the sale of units. And number three is its payment to the main contractor against their invoice.
My lord, yes. And what he's saying is I understand.
And it's all the same 925,000.
Precisely.
And it's all June 2017.
And it's all transferring the money to FZE.
Well, what's interesting is that apparently Kennedy's refused to effect the transaction when Mr. Varma said transfer it to GCFZE, which of course the UAE company, bearing in mind the hotel's in Bristol. The Kennedys went on to effect the transaction, putting the money in Mr. Varma's personal account in the UAE. But, my lord, you have the point. Various inconsistent explanations for the same thing were given. And what the judge very properly is doing is saying, well, this is part and parcel of the same transaction. And so I have regard to the fact that he can't keep his story straight on the 925,000. He still can't, by the way, my lady and my lords, because he said in his witness statement supportive of his application to adduce fresh evidence that Mr. Khadka received money for this. That's never been any part of his case. He's always accepted that he received the money and that GCFZE received the money.
I hadn't spotted that.
So where did the money ultimately go? It went into his personal account in the UAE.
Yes, so some of the money went into his personal account in the UAE. That's the 925,000. 3.1 million went into the GCFZE's account in the UAE. Of that, it was transferred over into Mr. Varma's account, and then it went to the Sun. Next, the learned judge, deals with Mani Singh, which we've dealt with and I won't dwell upon. You can see that the judge is very careful there and says, like the Deputy Judge on Yellow QC, this is about 2/3 of the way down, I don't ignore the fact there are 2 letters purportedly from Mr. Singh. We conclude that the evidence overall does not support the involvement or even the existence of such a person.
But his finding to the criminal standard is not that Mr. Singh doesn't exist, it's that there was no involvement of Mr. Singh in the company. That's the second sentence of that paragraph.
Yes.
Or that the decision to buy the jewellery was a decision of Mr. Manit Singh.
Yes, and I note when I read that, my lord, that he uses the magical words, if I can put it that way, I am sure.
Yeah.
I feel that you're anticipating the submission that I'm going to make, which is that if he was sure, for example, that Mr. Varma was in London, which he was, and not Mumbai, then that alone destroys Mr. Varma's case, because Mr. Varma said he was on pilgrimage in Nepal and then came to Mumbai to do this diamonds deal. But if there are various findings, all of which are destructive of Mr. Varma's narrative to the criminal standard, then cumulatively or alone, they are enough. And the fact that the diamonds do exist, which we respectfully doubt, is neither here nor there. There's not a jewellery issue. There's an issue about whether the jewellery was bought by the company. And then he goes on at paragraph 5 to deal with the settlement agreement. And I hope it's permissible for me to say that this is also a very good bit of judging. Because, of course, Judge Agnello had already found that the settlement agreement was a fabrication to the civil standard for cogent reasons, the sort of reasons which don't feature, for example, in the judgment of Judge Prentice. The evidence of Nianta Wara, I remind the court, was directed at showing that it was her using Mr. Varma's bank card in London at the material time. That was pursuant to some sort of elaborate loan arrangement where she had paid for, Mr. Varma said, expenses at a family funeral. And then Mr. Varma, in exchange, had given her his bank card when she was in London to use instead of effecting a simple bank transfer. Mr. Varma took refuge at one point in the assertion that the rupee is not a convertible currency. The finding he makes there, which I think is tantamount to a finding of a fabrication, is that the settlement agreement has, as I find, been created to make pursuit of the company money more difficult. It is not reliable evidence of jewellery sale. He then makes clear that he's taking into account the familial evidence and gives a good reason why he doesn't believe that. And this, my lady, is relevant to what I'll come on to say about the family evidence, part of which is just, well, so what? I mean, if there is this rift, they're not going to attend to help him if you order a retrial before a different judge. He had a deadline to put in his evidence, which was November 19. He put in his own evidence. He then put in late evidence from Vinay Varma and from Nianta Bois, which dispassionately we said we would allow in, given the circumstances. But evidence like that carries very little weight if people don't come to be asked questions by counsel.
Am I missing something? It is possible to be in Mumbai on the 11th of June and London on the 12th.
I think it's possible.
I've done it myself. Not necessarily those months and those days. But
I think it's possible to be in both cities on the same day. One gets the right flight.
If you get the early flight.
Yeah, but that was no part of his case.
He just simply said, A, I was in Mumbai. B, I did the 12th of June transaction.
The point was taken against me. We were looking at the bank statements, and the point was taken against me. Well, Brown suggesting that the transaction date is the same as the date that it's recorded on the account, and so we had a debate through questioning, which covered the whole range. So we looked at various payments to doctors in Bicester Designer Village, in Selfridges, that covered the date of the potential transaction and the date on which it was recorded, in order to make sure that we could demonstrate our case that Mr. Varma was in London and not Mumbai, as he claimed. But there was no part of his case that he'd managed to jet set between the two. He didn't give clear evidence on...
Well, I think if you go to Mr. Gray's affidavit, bundle page 271.22, tab 10.1, he gives a series of transactions spanning the 7th of June to the 15th of June, all of which take place in the UK.
That's exactly the point, my lord, that I was clumsily trying to make just now. The he then deals with the evidence of Niantibois, saying that he doesn't ignore it. Mr. Varma, in fairness to him, confirmed that the spending at the doctors at the material time was his. Next, and this is the sort of thing that can be lost in the wash, my Lord Justice Lewison has referred to a deed of gift earlier in this hearing. There were two deeds of gift, or deeds of transfer, that Mr. Varma alleged existed. One was between him and his son, which we say has no materiality whatsoever.
That's the one the son gave evidence about. He went
Exactly.
to the solicitors and
Yeah, he did. Yeah. And we say it's got no materiality to anything. It's common ground. Mr. Varma originally lied about it before Andrew Hockhauser QC, when he said his son didn't receive the £2 million into his bank account. After that point, it became common ground. Mr. Varma accepted that his son did receive money into his bank account. I should say he had to at that point, because he didn't comply with the Section 39 order made by Adam Johnson QC, sitting as deputy, to produce GCFZE's bank account. So the joint liquidators had to send me to Dubai to go to the court of first instance in the DIFC. And we got the equivalent of bankers' draft orders over there, directing the banks directly to produce the bank statements. So it was only through those bank statements that we discovered that the £2 million had been paid to the son. And it was only through those bank statements that we were able to do the analysis.
From whose account?
From Mr. Varma's account. And it was only through those bank statements that we were able to put in that evidence to which you, my lord, have just referred.
of the transactions.
Exactly, spanning the dates when he says he was in Mumbai. The other deed of gift is the deed of gift that Mr. Varma has always claimed existed, transferring the money, of him transferring the money to GCFZE.
Transferring the jewel.
Excuse me, the jewellery as a capital contribution, forgive me. And that's what the sixth reason, paragraph 47, deals with in a learned judge's judgment.
Yes, he says he got the jewels from his mother. He gave them to GCFZE, which then sold them to Grosvenor.
Yeah, that's it, exactly. And what we relied upon here was that there was no evidence. For example, one might see a trust instrument showing that Nirmala Varma had transferred the money to him. There's no evidence of that sort. This gift deed, which is Sanjeev Varma GCFZE, has never been produced. And you'll see the reason Mr. Varma gave for, by way of excuse for not having produced it, which was that it was in a fingerprinted, secured safe in an apartment in Dubai, which he can't access because we've got his passport. And this is the eighth reason that doesn't feature in this list, which is that the judge says that I am sure that there is no exculpatory cache of documents in a safe secured by fingerprint in Mr. Varma's apartment in Dubai. So and this loops back to the point the lady was asking me about before the break, and why I say it's neither here nor there whether the diamonds or jewels exist, because what he had to prove to disprove this allegation of contempt was that the company received the diamonds and jewellery, and there's still not a shred of evidence of that, and there was certainly not a shred of evidence of it before this judge.
So this deed of gift referred to in paragraph 47, this is said to be Mr. Varma transferring the diamonds to GCFZE, not to the company.
My lord, yes.
And then they've got to get somehow from GCFZE to the company.
My lord, yes.
And that happens in settlement of certain unspecified claims in June 2018. Meanwhile, the son has got the money in 2017. Mm-hmm. Was a date ever put on this deed of gift referred to in paragraph 47?
No. We've never seen it. It's never been produced.
No, I follow that you haven't seen the document, but did Mr.
No,
Varma...
no, not to my knowledge. I'll check.
But I thought that the jewels made their way from GCFZE to Grosvenor via the invoice. But the settlement agreement was a bit later. That was a release of some of the balance of the purchase price. So but when you say there's no evidence that Grosvenor received the jewellery, that's because Mr. Varma's case is that Mr. Singh asked Mr. Varma, qua GCFZE, the seller, to hold them on trust for Grosvenor, at that stage owned by Mr. Cadker.
Milady, no.
Oh.
Mr. Cadker was appointed as director on the 9th of June 2018.
All right, well, not owned by Mr. Cadker.
In terms of the shareholding, as a matter of record, it was always Jonathan England.
Yeah.
Judge Agnello found that Mr. Varma was de facto director, and that he was the true owner and controller of the company. It's always been Mr. Varma's case that that's Manit Singh.
What was the date of the invoice?
27th of June 2017.
Right. And what was the date of the transfer of the 3,122,000?
At various dates. So it was between June 17 and October 17. And in relation to that invoice, milady, you'll see it referred to at the bottom of paragraph 44, the learned judge's judgment. And he says it lacks all credibility. Excuse me, it lacks any credibility.
And when did the son, Mr. Varma Jr., get the £2 million?
It's in the Prentice judgment. I believe it's the 8th of August 2017, but I'll check.
I'm still a bit puzzled. There is an invoice from 2017,
Yes.
which is said to show a sale by GCFZE to the company of the diamonds.
Well, it's said to be an invoice.
Invoice.
Yeah.
And Judge Prentice thought that looked as though there was some kind of sale, if you took it at face value.
I'll come on to his judgment in due course.
Just a matter of curiosity, do we have that invoice in our bundles?
I don't believe we do.
Right, but if then there is almost immediately there starts being the payments out, which ultimately amount to the 3,122,000, that would suggest that the jewellery was sold, turned into money almost immediately.
Well, that was what the invoice was.
Unless other funds, I suppose they can use, depends what other funds they've got. You don't have to pay for them by selling them.
It was the 8th of August. I found it in the Prentice judgment. It's paragraph 201.
2017.
Yeah. Yes, milady. So the invoice is one of the documents that Mr. Varma produced when he was required to produce company documents under Section 234, and it was found to lack all credibility.
Yes, I know. I'm not saying I believe what I believe, but I don't believe. I'm just trying to get in my mind the chronology of what is a possible version of events, so that then you can see whether it would be affected by this new evidence.
Yep. I want to stress the commercial implausibility point here. So we understand that the cost of the hotel was 5.5 million. So by making these transfers, the company rendered itself insolvent. If it received diamonds and jewellery, they were being held offshore by a brand new director who would be left holding, on Mr. Varma's case and what Mr. Kadka says, £5 million worth of assets. The next point in the judge's judgment which is critical in relation to the finding that there's no stash of exculpatory documents, is that those documents that he did produce, he was able to produce without visiting Dubai. We say he only produces documents when it serves him. You can see a particularly sensitive appreciation of the burden of proof he had to apply in his seventh reason.
Right, so the crucial finding at 49 is... Right, and we now know, I think, that those words in quotes were paid against the sale of jewellery and diamonds to the company. That is a quote from the
answers
affidavit.
Compelled
Yeah.
To be provided by affidavit under the order of Mrs. Justice Falk in response to particular questions by the joint liquidators.
And you say it doesn't matter whether the diamonds did or didn't exist. The finding is that they weren't paid against the sale of, well, the money wasn't paid against the sale of jewellery and diamonds to the company.
Yes, and even if they do exist, there are multiple cogent reasons of which the judge was sure why that payment against the money, why that payment of money didn't happen against provision of diamonds and jewellery. That's the short point, my lord. And I'm reinforced, I say, in my submission on this, by the astonishing lack of evidence before the court of the existence of the diamonds and jewellery. I mean, is it really being said?
Let's not get sidetracked by their existence when we've just spent a while getting away from the relevance of their existence.
Yes. Sorry, my lady, I was hoping to make a pragmatic point that if these diamonds and jewellery do exist in the physical world, and they've been in the continual custody of Mr. Kadka, then he could have taken a snap of them.
Yes, but that doesn't get over the point that you pursued Mr. Kadka for the delivery up of the diamonds. You got an injunction from Mr. Justice Burse for the delivery up of the jewellery.
May I interject, my lady? Just to say that I adopt what was said by Lord Justice Lewison and Lord Justice Stuart-Smith in relation to this, that our claim wasn't based...
Yes, your claim is in the alternative, I think.
Well, yes, and it was never based on a positive assertion that diamonds and jewellery existed. And if one looks at the injunction, which mandates Mr. Kadka to deliver up the property, it isn't based on any sort of acceptance or assertion that the diamonds and jewellery do in fact exist. And we haven't... he's got to deliver up such company property as he has. We've got a money judgment against him based on admissions that he has company property to that particular value. So I don't think it can be taken against me fairly. And I accept my own friends. Not only new to the case, but wasn't counsel before Judge Prentice. But it can't be taken against the joint liquidators that they have in any way positively asserted that the diamonds and jewellery do exist. There's no part of their case. They come as complete strangers to the company. and they haven't had evidence which enables them to form a professional conclusion that the diamonds and jewellery do exist. They still haven't.
Right, so my concern with this case has been to avoid getting into a situation where Mr. Varma is held to be in contempt of court for saying that the diamonds exist when they don't, and then Mr. Khadkar is at some future time held to be in contempt of court for failing to deliver up the diamonds, having been ordered to do so, and that would obviously be a very unsatisfactory situation.
Well, I can
but your answer to that, as I understand it, is the contempt finding in number 1 is not as to the existence of the diamonds or not. It's as to whether the diamonds were the consideration for the 3.1 million and 925,000
My lady,
pounds on the one hand, and that you're not asserting that the diamonds exist in your claim against Mr. Khadkar, only that if they do, and they are the property of the company, he must deliver them up.
Exactly so.
Can you just show us where the delivery up order is? Looking at Mr. Justice Burse's order in section supplemental bundle 1, section D, tab 17, starts at page 3, D19. There's a freezing order.
It's paragraph 24, my lord.
Right.
And you'll
Paragraph
see
7 talks about the diamonds and jewellery the first and second respondent claim the company purchased. 21, do you say?
24, my lord.
24.
Page 325, and you'll see how that's carefully worded.
Diamonds and jewellery the first thing assert that the second respondent is holding. Yeah.
And you'll see that over the page, my lord, which is worth reading, because of his flip-flopping on whether he'd liquidated them or not.
Yeah. Right. Thank you.
And, my lady, there is no application to commit Mr. Khadkar.
No, I know, but
I understand
Yes.
concern. And I repeat what I said, echoing Alicia's observation earlier. Of course, if the diamonds and jewellery do turn up, they'll go into the liquidation estate and credit will have to be given for them in respect of the judgments that we have against the various defendants. May I now deal with... So I think in making those submissions, I hope in making those submissions, I have dealt with what I say is the complete immateriality of the fresh evidence that's been sought to have been introduced. And what I'd like to move on now to do is deal with whether or not the joint liquidators have any duty to disclose, which is critical here. And I will come on, my lord, to address Lord Justice Stuart-Smith's question about the pilot 51U. I say that the criticism of the joint liquidators is an attempt to presuppose the outcome of a disclosure application that was never made. Mr. Justice David Steele, in the first instance decision in Marsary, considers a disclosure application that had been made, and he asks that courts ask in respect of disclosure application against the backdrop of the power to exercise and to make an order for disclosure being exercised very sparingly in the context of an interlocutory application. Contempt proceedings are, of course, satellite proceedings. He's actually referring to his own decision in Fiona Trust and Privilov when he refers to the words very sparingly. And the sorts of questions that judges ask on those applications are, is this material to an issue? My lady, you know what I'd say about that now. It's not. will it assist the judge determine the dispute? No, it wouldn't. None of this evidence would. Is it proportionate? And critically for this application, is it something in respect of which the respondent has a duty of disclosure? So I'll take one document as an example. The letter from Nirmala Varma to Sanjeev Varma. Well, that's a Sanjeev Varma document. The only person that can have produced that is Sanjeev Varma. It's not a document which we have a duty of disclosure in relation to. I also want to make a practical point, and I say this is a point which is fatal to the criticism of the joint liquidators on the basis of disclosure. Mr. Varma has had access, and his lawyers have had access, throughout the period of the committal application, to the CE file. And so what we saw, he saw, or could have seen with reasonable diligence.
Are all these materials on CE file?
The evidence that's been filed is. And so it's a quite extraordinary proposition. My learned friend makes some submissions which are very easy to agree with, that committal proceedings should be fair, and they should be particularly fair, and there should be real caution to ensure that they're decided to the correct standard, and the respondent should have an opportunity to put in evidence and not to put in evidence, for example, if the respondent so chooses. The proposition that's being put is that we should provide things that have been provided by Varma family members to Mr. Varma when he has access to that stuff on CE file, and his lawyers do. It's all under the same case number.
Well, have they been provided to him?
Has what been provided to him, my lady?
Well, what we were taken to, I thought, by Mr. McCormick was that list of, is it right at the back here? The
Page 105, 106 of the application.
right.
Well, my lady, I think the short answer is yes. I mean, Mr. McCormick says that there's no application now for disclosure. So everything's... We've been criticised for not disclosing matters that are said to be adverse to our case.
Yes.
But no application for disclosure has ever been made.
Well, because they didn't know that.
My lady,
So
who's they in your ladyship's question? Is it the lawyers for Mr. Varma? Because if it is the lawyers for Mr. Varma, my lady, they knew that the trial was going on.
Right, so this letter is from your clients to Mr. Varma's solicitors, actually enclosing the material that he's now adducing in this hearing, which you say you got from Keystone on the 10th of June.
Yeah.
And what's said against you is, on the 10th of June, you should have realised that those documents, or some of them, were adverse to the case you were putting in the ongoing committal proceedings, and you should have disclosed them. That's what's said against you.
Yes. Yes, and what I'm addressing now is not the assertion that they're adverse. I've addressed that under the headline of materiality. We don't accept that these documents can possibly be adverse to our case. Not least because Taru Dumra and Siddhant Varma say what Mr. Varma said, what he told them, and as I'll come on to show, Siddhant Varma goes on to say that he was the victim of a lie told to him by his father, which doesn't help Mr. Varma one bit. So So that's the practical point. The next point is that there's no legal basis that I have been able to identify in Maloney Friends' submissions for the duty of disclosure that is being asserted. It's on my clients. He rightly, if I may say so, has abandoned the reliance placed by Mr. Leonard, Mr. Varma's previous counsel, on the Attorney General's guidelines. These are civil proceedings, and there's plenty of authority on that. And so disclosure is governed by Part 31. I haven't forgotten your Lordship's question. There is no general duty of disclosure. The duty of disclosure only arises if and when the court orders disclosure. If a reference in the White Book is wanted for that, 31.0.3. There was no duty of disclosure in this case because there was no order for disclosure.
I think it was Mrs. Justice Falk who gave directions for the committal hearing.
That's exactly right.
There certainly wasn't an order for disclosure there. There was an order for service of evidence.
That's right. My Lord, I want to point out some other things about that hearing. Mr. Varma was represented by counsel. He had solicitors acting for him on legal aid, and counsel acted on the same basis. And those directions were agreed. The next time directions were given were by Mr. Justice Fancourt.
That was just for the adjournment.
Yeah. Mr. Leonard was then instructed on a legal aid basis. Different counsel, the previous counsel was Mr. Lyons, and different solicitors were instructed by Mr. Varma. There was a gap in the period of representation between those two hearings, about a day when he changed solicitors. But at that stage, it was known by Mr. Varma's solicitors that the trial was going to be the week after.
The Prentice trial you're talking about.
Exactly, the Prentice trial was going to be the week after the committal hearing. And just as a thought experiment for the court, and I'll come to try and make good this submission by reference to Marsry, what sort of disclosure order would he have been applying for, which would have been granted to him? If he had applied at that time for a disclosure order, which he didn't. If we look at the decision of David Steele in Marsry, it's instructive in my submission.
It's tab 6 in our authorities bundle.
Yes. You have got the practical submission that I'm making. I hope it's a practical one. That Mr. Varma had all the opportunity in the world, knowing that the apprentice trial was forthcoming, to apply for such disclosure order as he thought was appropriate, or indeed to apply for a disclosure order against the joint liquidators at any point if they had any evidence of the existence of Mr. Manit Singh or the diamonds and jewellery. We don't need to worry about the evidence of Manit Singh because that's come from Mr. Varma and it's come by way of fresh evidence from his former solicitor. But if we look at paragraph 20 of the decision of Mr. Justice David Steele, this is a case management conference in the context of committal application, where an application for disclosure was made. And it's worth reading all of paragraph 20 through to, if the court doesn't mind, 29. come back to the thought experiment that I posed for the court. He says this in paragraph 24. Application 1 is a general application for disclosure of all documents which might reasonably be considered capable of undermining the case for the claimant or of assisting the case for the first and second defendants. He then goes on to address the Attorney General's guidelines, though he says correctly, as a matter of law, they don't apply, but says even under that, you wouldn't get a disclosure order of that nature. He then goes on in 27 to say, no general, let alone mutual obligation of disclosure arises. He observes, I'm always wary of the sort of anecdotal evidence of what makes it into authorities and what doesn't. He observes, and I note that this was litigation on which considerable amount of money was spent, or I infer that from the representation. He observes at the end of paragraph 27 that it says, indeed is of some note that no example in the authorities was produced by the defendants of any order for disclosure in the run-up to a committal order. And if one stops and thinks about it for a moment, that makes sense. Of course, I couldn't mislead the court. I couldn't put a question or make a submission if I considered that it didn't have a proper basis in fact or evidence. Mr. Varma couldn't be compelled to produce anything in his defence, but he did. He is the person who was on both sides of that transaction. He said he was the consultant to the company. He was found to be the de facto director. Mr. Singh doesn't exist or had no involvement, so he can be taken out of the equation. He wasn't the ultimate beneficial owner. So this was a transaction between Mr. Varma on the one hand for the company and Mr. Varma on the other hand for GCFZE. The involvement of Mr. Khadkar is just dubious given the date on which he became a director and given his conduct since. You'll see in para 29 that the application for general disclosure is refused. And so that's why I posed the thought experiment. What sort of order is it that would have been obtained that I'm now said I would have been in breach of by not providing documents from Mr. Varma's own family? It's impossible to imagine a disclosure application that would have succeeded in the generality of the terms that is now being put by my learned friend. So if you find that we were in breach of a disclosure obligation, not that a legal basis for one has been identified, you'll be retrospectively imposing on the joint liquidators a duty which they did not have under the general law. In respect of a disclosure application which would be so vague in its content that it would never have succeeded in any event.
Well, in respect of a disclosure application that has not been made.
Yes. Despite legal representation throughout and two clear opportunities where it could have been made. And of course, I have paid particular attention to the hearing before Mr. Justice Fancourt, because we were in the teeth of both hearings there. And so Mr. Varma's solicitors, who had access to the CE file, were well aware at that time that there was going to be evidence given in those proceedings which may or may not overlap. But even back when the original directions were given, no application for disclosure was made, and Mr. Varma's team will have known then that the proceedings were still ongoing insofar as they related to Ds 2, 5 and 4. Can I also trouble the court just to look at, just by way of illustration, at paragraphs 40 through to 41?
Of Masri.
Of the same case, yes.
Yeah.
Learned Junior Mr. Shipley has passed up a note correcting me very properly. The directions hearing before Mrs. Justice Fogg was pre-amendment of the claim to include a claim against the fourth defendant. So I retract the submission that they would have known then that there may be a trial.
Yeah.
They would have known, and I'll look at Mr. Shipley when I'm saying it, that there was a claim against Sidant Varma. It was amended to include the claim to the 2 million, which brought in the question of the inheritance. The claims against all the other defendants were live, so my submission was slightly incorrect, and I apologise. The reason I've taken the court to paragraphs 40 through to 41 is that it's just an illustration of the sort of questions that a court asks itself on a disclosure application. You know, are they going to help? Are they proportionate? Whose documents are they? Who has the duty? The application's rejected. Here we have no application at all, and the joint liquidators are now being criticised without a duty of disclosure having been identified in the law. Next, I want to deal with Masri and the Court of Appeal. We have tried, but we have failed to find. It's over the next tabs, tab 7. We've tried, but we've failed to find Lord Justice Ricks's permission judgment in this case. But it's recorded in paragraph 26 of Masri in this court, which I'd invite the court to read.
Yeah.
So the assertion that my learned friend now has to make that we have a general duty of disclosure somewhere in the law, as yet unidentified, is an assertion that didn't get permission before this court in Masri. And then the only other paragraphs of that judgment that I would like the court to read are paragraphs 40 through to 43, which effectively say that the analysis of David Steele, Mr. Justice David Steele, was spot on. My learned friend has relied on the decision of Mr. Justice Tier in the Abliazov case, which he read to the court earlier, and I won't repeat that process. But I would say this about this case. One, it was a directions hearing, so it's not a place to find authority when there's an authority of the Court of Appeal on this direct question. Secondly, in that case too, an application for disclosure was made. Thirdly, it was decided per incuriam of this court's decision in Masri. Thomas Grant, who appeared for the defendant, who's the author of the civil fraud book to which I've made reference, doubts the proposition stated by Mr. Justice Tier in the passage which my learned friend has cited. I think that is with, if this isn't disrespectful to either of them, some unfairness to Mr. Justice Tier. So I doubt Mr. Justice Tier would be thinking that people would be poring over his decision in this context when he was making a decision in a case management conference. particularly in that case, he was overburdened with documents. One of the complaints made in Marsbury was that lots of applications were made on the day before the CMC. Well, that's better than what's happened here, which is we're being criticised for not disclosing things where there's been no application for disclosure in any event. I now address, if I may, my Lord Justice Stuart-Smith's question, which is a point that hasn't been raised by anyone else.
This is about whether the pilot applies, is it?
Sorry?
This is about whether the pilot applies,
Yes,
is it?
exactly.
Well,
And
you've answered it already. Haven't
well, I would hope I
you? In
have.
the sense that you say there's no disclosure obligation at all.
I have answered it, but I want you to believe me, my lord. So I'm going to take you to what is said.
So we need volume 1 of the white book.
Volume 1 of the white book.
Yep.
Yes. Page 29. You might recall that there were various practice notes that came out after the disclosure pilot when it was realised that council had absolutely no idea what they were doing in relation to the disclosure pilot, and there was various guidance given by the heads of various divisions and subdivisions of the courts. One of these, from the Chief Insolvency and Companies Court Judge, is on page 1729, and it says this: materially to my Lord Justice Stuart-Smith's question, the disclosure pilot applies to Part 7 proceedings with statements of case. Part 7 claims without particulars of claim, and Part 8 claims are expressly excluded from certain of its requirements. Forms of originating process familiar to users of the Insolvency and Companies list, such as petitions and applications, are not statements of case for the purpose of the disclosure pilot. It then goes on to say the court may, as part of its case management powers, consider it appropriate to order disclosure in proceedings commenced by Part 8 claim, petition or application, either of its own motion or on the application of a party. No application was made, no order for disclosure was made by the court of its own motion, nor would any order ever be made, because these are interlocutory proceedings, and the discretion to order disclosure is one that's to be exercised sparingly. The point here, my Lord, procedurally, is that this was an insolvency application, so it doesn't apply.
Because it's not Part 7 proceedings with statements of case.
Precisely, and it's expressly excluded there by the Chief ICCJ when he says it doesn't apply to originating processes by application, which is what this was. It started life as a 234 and 236 application. I'm just silent because I'm crossing out submissions, which I hope is welcome news. Things we've already traversed. Slightly in two minds about making this point in circumstances in which the respondent has no duty to provide any evidence at all. But the joint liquidators do say there's an element of perversity in the criticism of them for not disclosing documents. They're being criticised for the non-disclosure of documents, some of which originate from Mr. Varma himself, some of which originate from members of his family, which their view is have no materiality. The more precise point is that they go to a transaction which Mr. Varma effected. So he's the only person who can really tell the court whether that really happened. He's the only person who's in a position to provide evidence about it. Quite why the joint liquidators are supposed to have an obligation in relation to that is beyond them. I'll address inconsistent judgments if I now may do so. Can I take the court to the grounds of appeal? Core bundle, tab 2, 11.10. The reason I want to take the court to this is we've had some difficulty responding to it. I'll take it sentence by sentence. The contempt hearing, which is the subject matter of this application, took place the week before the separate trial before HHJ Prentice between the claimant and the other respondents in the claim. That's agreed. Next, it says this. The Prentice judgment came to different conclusions on matters highly material to the committal for contempt trial hearing by His Honour Judge Johns QC. I want to pause there. So you've already got my submissions on materiality. I couldn't find anywhere in the Prentice judgment, if I can call it that, where he says positively that the company did receive consideration for the 3.1 million. To the contrary, my lady and my lords, certain of his findings are based on the company not having received the diamonds and jewellery. So, for example, his judgment against Jonathan England is based on the company not having received the diamonds and jewellery. And also certain of the things he considered.
In what way is the judgment against Mr. England based on?
So Mr. England was the statutory director, my lady, of the company at the time when the 925,000 was paid over and when the 3.1 million was paid over. And part of the judgment sum against him is comprised of those two amounts, which were misappropriations of company property.
But they would be misappropriations even if they were consideration for the purchase of the diamond.
This is your ladyship's breach of fiduciary duty point.
Yes.
Yes, that's right. But nowhere does he say the company did receive diamonds and jewels for the 3.1 million or the 925. And if one thinks about it, he considers various things that he wouldn't have had to have considered had he made such a finding. In particular, whether or not Varma, the son, knew of the source of funds. And I'll develop that submission down this page. But before we get there, it says this. The fact of different conclusions in a later judgment is said to amount to a serious procedural or other irregularity which renders the conclusions of His Honour Judge Johns QC unjust within the meaning of the relevant rule. I want to pause there again. I simply do not accept, as a matter of law or as a matter of principle, that the fact a later judge comes to a different conclusion can conceivably render an earlier process unfair. There were lots of steps that were taken to make sure the process involving the committal application of Mr. Varma was fair. Sorry, my lord.
Well, I understand that, and I can understand why you say that. But there might be circumstances a later finding rendered it unfair to act simply on the basis of the earlier judgment, which is different.
Yes. And I agree, my lord, and I would say...
In theory. I know your submissions are that doesn't apply here, but...
Yes, that's not on the facts of this case, but I accept in principle that would happen. But, for example, if one just takes the word serious procedural irregularity, it's absurd to suggest that something that happened later can form a procedural irregularity in the procedure that led to the judgment of His Honour Judge Johns QC. The features of that procedure involved him having an opportunity to put in evidence, having ample time to put in that evidence, being allowed to put in late evidence, being told he had the right not to self-incriminate, being able to make such applications as he thought fit.
I think you're taking a rather... how I read this was that, say, if one can put it slightly differently, that it would not be right for Judge Johns now to go on and sentence Mr. Varma for finding one
Yes.
in the light of what has come out in the trial before Judge Prentice. I think there are circumstances, things might have come out in Judge Prentice's judgment or the hearing, which would mean that when Judge Johns came to sentence Mr. Varma, you wouldn't ask him to commit him to prison or impose a penalty for the contempt one or contempt whatever. I think.
Milady, yes, I accept that's a theoretical possibility. At the moment, I'm just pointing at what I say is a defect of logic or a defect of pleading in the ground of appeal. And it's not just a defect of pleading. Because if one looks further down, it says this: the competing findings of fact can be summarised as, and then I'd invite your lordships to read 4A carefully, please. Respectfully, none of that makes sense. Again, the error is repeated that the second respondent received money. It's never been part of anyone's case. Second respondent is Arjun Khadka, who is said by Mr. Varma to be the custodian of the diamonds. The second sentence of 4A isn't complete, but ICCJ Judge Prentice did not determine them, that is the diamonds and jewellery, only to have existed, but had been provided to the appellant, leading to 2 million. I don't know what that is. And the reason this doesn't make sense, and the reason that it can't be formulated...
So it had been provided to Mr. Varda, is what that's saying, is it? Not to the company.
Yeah.
Mr. Varda's the appellant.
Mr. Varma's the appellant. You see where it says why the second claimant company had provided the second respondent with various amounts of money transfer.
Yeah, I follow that. You say, well, nobody's ever suggested that Mr. Kaida was provided with money, but you then took us to the next sentence. Judge Prentice determined them, which is presumably the diamonds and jewellery, existed but had been provided, that is the diamonds and the jewellery, to Mr. Varda, leading to £2 million. That presumably is the payment to the son. But it's not asserted there, is it, that Judge Prentice determined that the diamonds had been provided to the company?
No, nor could it be. And then 4B is similarly perplexing to respond
So
to.
who's the second respondent?
Second respondent's Arjun Khadka, my lady, the supposed custodian of the diamonds in Nepal or Mumbai or wherever he currently is. 4B, similarly perplexing, is Honour Judge Johns QC identified the provision of to the fourth respondent,
That's the son.
that's the son, as a basis for finding a contempt as an illegitimate transfer of company funds. I don't know what that means.
Well, there was no dispute that the 2 million had been provided.
Milady, yes.
Even at the time of the committal proceedings, it was clear that the 2 million had been provided from the company's money, and that was the basis of the contempt finding. The rest of that sentence.
Yes.
That Mr. Varma had said that FZE had used the money in its ordinary course of business, basically.
Yes, and my lady, it's worth looking at that now. So tab 8, page 64, para 7. This is, my lady, the second part of that false statement.
Sorry, I'm
It's okay. Tab 8, page 64, para 7.
Yes.
So, Milady, I think your ladyship already has the point. It was common ground, and it was accepted, at least after we'd got the bank statements from the DIFC, that the 2 million was transferred to the Sun. And what His Honour Judge Johns did was say, well, that's a false statement that you've made there, because you didn't say that £2 million went to the Sun. It's common ground between everybody that it did. So 4B, just as well as being an incomplete sentence, is factually unsupported by anyone's case in these proceedings. I looked to the skeleton argument of Mr. Leonard to see whether it was expressed differently, and it's not. It's just, well, there's one difference. There's a full stop at the end of one of the incomplete sentences. But it's just copied and pasted from the grounds of appeal. It's perplexing to respond to. Next point, if I may just have a moment. Again, I'm just crossing through submissions that we've already canvassed in the hearing. So I should show you where the judge makes that seventh finding of contempt. It's at tab 8, page 60, paragraphs 153 to 156. That finding, in my respectful submission, is unappealable.
Yes.
The next problem with the assertion that the Prentice judgment can possibly be a basis, as we have posited together, for determining that there was some irregularity or that there was an injustice in allowing us to proceed on to a sentencing hearing in respect of ground 1, is that Judge Prentice heard from no one who could give direct testimony about the existence of the diamonds. And Judge Prentice was alive to this, and he says so in his judgment. In particular, at the top and bottom of paragraph 8, he says this. Excuse me, at the middle and bottom of paragraph 8, he says this. Whether the jury...
Could you just remind me where it was?
I'm so sorry, I was racing ahead. 28, tab 28, D445.
Thank you.
So he says, whether the jury actually exists or not is a matter which will have to be determined without anyone who has ought to have seen it. It then goes on to say, this is at the end of the paragraph, this trial will be determined without having heard direct evidence from any of the direct contributors to the fraud.
Well, the paragraph you have just read,
Yes.
the sentence you've just read, suggests that Judge Prentice thought that he was going to determine whether the jewellery did or did not exist.
Yes.
Did he do that?
He did determine that the jewellery existed. He also determined that the inheritance existed.
Right.
What he did not find expressly anywhere is that the jewellery and diamonds was given in consideration
Right.
for the 3.1
So
million.
the existence of the jewellery was inherent in his acceptance of the son's account,
Yes,
that there was to be the inheritance from his grandmother.
my lord, precisely.
Right.
Yes. Now, Sanjeev Varma was party to all of the transfers which were alleged between Nirmala Varma, Sanjeev Varma and GCFZE and GCFZE and GDPL. He had months to prove that they took place, or any of them. He relied on evidence from his brother, who did not attend trial, but said he attended the diamonds transfer. You might have picked up, my lord and my lady, the date problem from our skeleton argument in respect of what Mr. Khadka says about his involvement. He says he was engaged in relation to the settlement agreement for the 11th of June 2018, and that he goes to the house of Nirmala Varma, and she died in January 2018. I should say the date of that visit is not said expressly, but it's between two paragraphs that refer to the 11th of June 2018, so it's implicit, it seems to me, that he's saying that she was alive at a time when she wasn't. That's against the backdrop of Mr. Varma already being inconsistent as to that point, whether it was a lifetime gift or a legacy. In the result, I say, His Honour Judge Johns, hearing from the protagonist, Mr. Varma, and having evidence from Vinay Varma, who was supposed to have been there, was immeasurably better placed than Judge Prentice to decide whether or not the company received diamonds and jewellery in exchange for its 3.1 million and its 925. I've made the point already that it's still the case.
Wait, who was supposed to be paying the commission to Mr. Varma of the 925,000?
Mr. Varma says he was entitled to that commission as a matter of convenience because GCFZE owed him money on some other transaction. And that was featured in the judgment of His Honour Judge Johns.
Was the 925,000 supposed to be part of the purchase price, or was it something separate?
It was, as I understand it, part of the purchase price. I say as I understand it because I'm referring to Mr. Varma's case, which hasn't been consistent.
Well, so the purchase price is just over 4 million.
That's right. The purchase price was 4 million exactly.
Of which, well, all that number of crores, and 3.1 million we know about, and 925 is the balance.
Mr. Varma hasn't been consistent on whether or not it was a commission. He ended up saying before Judge Hockhauser that GCFZE owed him that money for something else. I saw it would be an odd thing for this court to do, in my respectful submission, to overturn the first finding on the basis of the judgment of Judge Prentice for the reasons I've already given, but also for the reason that we've got this fresh evidence now from the custodian of the diamonds and jewels, who's had them all this time throughout these proceedings, and he still hasn't produced a scrap of evidence of their existence. I would have said, if we were doing a Ladden-Marshall analysis, that statement doesn't begin to get near to crossing the threshold of credibility, not just for the date reason, but also for the reason that he doesn't address when he's going to give us the diamonds and jewellery if they exist in the physical world. You've already got the point that Mr. Varma still can't get his story straight. It's 11.2 of his witness statement in support of his application, where he says Mr. Khadka received money he didn't. I want to pick up a point which you canvassed with my learned friend, my lord, in relation to the claims that were said to be owing, the reason that...
What was the claim that was settled?
yeah, can I take you to the relevant bits of the cross-examination on that? It's core bundle 9. Page 180. I apologise that the page numbers have been printed over the opus writing. So
118 or 180?
180.
Thank you. So internal page 145, manuscript, day 3. Is that what I'm looking at?
Bear with me, my lord. Sorry, it's 186. Do beg your pardon. It's internal page 172. I say internal.
Sorry, am I going 126, did you say? 186.
186. The internal pagination on the transcript is 172.
Yeah.
And if you look at where it says Mr. Brown at line 14 on page 172, and read through, please, to line 9 on the next page.
Yeah.
And then we come back to this topic at page 221. Which, using the quarters page number, is page 76. If you could read from line 9, please, through to...
We're still in your cross-examination of Mr. Varma, are we?
exactly so.
Line 9, yeah.
So if you finish reading at about where it says 77 on the next page, that's pretty much the right point, just beneath that. So in answer to Lord Justice Stuart-Smith's question, no good reason has been given for why that document was expressed to be in settlement of claims. Judge Anello accepted the submission that it was a perfect document to defeat a claim in knowing receipt. She found it to be a fabrication. That response was echoed by Judge Johns. That finding was echoed by Judge Johns.
Well, I mean, your submission on that evidence is incapable of belief because if it was a release, the claims must have been so substantial he would have known it.
As the director of the company.
Yep.
As the sole director of GCFZE, that was his own evidence, yes. May I move on to the specific challenges, which I'll be able to deal with a great deal more briefly. I'm grateful to my learned friend for taking you through the jurisprudence on Italy, which I'll come to deal with, and I'll deal with it very quickly unless you want me to take you to specific passages. The first challenge, which my learned friend didn't develop in oral submissions, was to the breach of the order requiring GCFZE to give disclosure of its assets. Varma did not swear an affidavit for GCFZE. His evidence was that he performed the role of director or equivalent for GCFZE. It's always been his evidence that he was the sole director of GCFZE. As Judge Johns identifies, no other person was identified by Mr. Varma as being able to act for GCFZE to produce the affidavit. Mr. Varma actually apologised at the hearing before Adam Johnson QC for GCFZE not having produced an affidavit. That's one of those reasons, my Lord Justice Lewison, that I was referring to earlier, that didn't make it into the judgment, but may have been in the judge's mind. At the result of that hearing, it's worth noting that Mr. Varma made submissions on behalf of GCSED to Adam Johnson QC. It's worth noting that he was ordered, pursuant to Section 39 of the Senior Courts Act, to facilitate the production of GCFZE's bank accounts. He specifically was ordered to do that. It wasn't an order on GCF for the respondent to produce the third respondent's or to facilitate the production of the third respondent's bank accounts. So after hearing from Mr. Varma, who represented GCFZE, he was ordered to do something for GCFZE, so he was the person to do it. The judgment also does not record that when Mr. Varma was subject to an order made in the Court of First Instance, the DIFC, which was a mirror or reciprocating order of the orders made here, he did produce an affidavit for GCFZE. So he demonstrated that he was the person to do it. I know this hasn't been advanced by my learned friend, so this is no criticism of him, but it's said that the statement of law by the judge was incorrect, and I reject that. The statement of the law by the judge is correct. His intention to disobey the order is no part of the text. So that deals with that specific ground of challenge. Breach, I'll now deal with the alleged problem with the breach of the order requiring a signed letter of instruction from Mr. Varma.
This is the forthwith point, is it?
No, forthwith is next.
Right.
I'll take you to the judgment so you know what I'm referring to. That's paragraphs 1 to 5.
This is to get the bank statements out.
Yes, it's the order I was referring to just.
Yeah.
It's tab 8, page 53, paragraphs 125 through to 130. And you'll see there, as I said, he specifically, that is personally, is ordered to send by email and special delivery a signed letter of instruction to GCFZE's bank, which he didn't do. Now, this is the point at which I'd like to address Italy. The first point I'd like to make is that Italy was not argued below, either in the skeleton or in written closing submissions. It was not argued until Sunday, when my learned friend took over the case. And I want to express my gratitude to my learned friend for calling me and saying that that's what he'd be arguing before I received his skeleton on Sunday. He also provided me with the authorities, which I was able to read in advance of seeing his skeleton, so I knew, if I may say so, where he was going to go. In my submission, motive is immaterial.
Sorry, what is immaterial?
Motive is immaterial.
That's not the point that's being argued.
Well,
Knowledge that what you are doing is a breach is what's being argued.
Sorry, I'm using a abbreviation there that I shouldn't have used. What I mean by motive is immaterial is that intention to disobey is not part of the test. Intention to disobey the order is not part of the test. My submission is that Italy, despite it being an authority of high level, should not be treated as expressing a principle beyond the boundaries of its own facts. My reasons are these. Some of them are technical and some of them are policy reasons. The first, as has already been observed by my learned friend quite properly, only the appellant was represented or attended. Stancombe and Heaton's, the latter being a case in the House of Lords, were not cited to the court in Italy. Stancombe, which is the decision of Mr. Justice Warrington, has since Italy been approved as good law in the House of Lords in the Director General of Fair Trading and Pioneer Concrete. it's important to note when one's reading the judgment of that at one point Lord Nolan is citing Lord Wilberforce, who's citing Mr. Justice Warrington. In that case, Lord Nolan cites two policy reasons why an intention to disobey should be irrelevant and should be no part of the test. The first is that parties in whose favour court orders are made are entitled to them being complied with. And the second is that the effective administration of justice requires obedience to court orders. I respectfully advance three more policy reasons. The first is this, with particular reference to this case, this type of case. Committal proceedings would be defanged in the circumstances in which they most need teeth, if an intention to disobey is treated as being part of the test. For example, in a case where a fraudster might not give proper disclosure of facts or documents to his lawyers, or might obtain convenient advice on the fly from disreputable lawyers. One can imagine an advice given on the phone by a lawyer who hasn't seen the order under scrutiny, or an advice given in writing by a lawyer who hasn't seen all the facts and documents. The second policy reason which I would like to offer is that if Italy and Pioneer Concrete were both treated as authoritative, you would have an odd situation where the machinery of contempt would be easier to invoke against corporations and lawyers than it would against individuals. Because to form the intention to disobey, knowledge of the law would be pertinent. The next policy reason is that committal proceedings are necessarily satellite. They can already mushroom into full-blown contested litigation, as the Masri litigation illustrates, even without inquiry into the legal advice that may or may not have been received, and without inquiry into a person's intention to disobey. I suggest those inquiries are disproportionate to the task at hand. It's also right to note that the decision in Pioneer Concrete in the Court of Appeal on the importance of the intention to disobey was cited in Italy, and it was reversed on that very point in the House of Lords, in the case in which a different capacity, Lady Justice Rose.
But I said to Mr. McCormick, Mr. Wadsworth didn't seem to have argued that there was no breach. He said that there was a breach. Seems to have been his positive submission that there was a breach, but it was an excusable one.
Yes. Yes, which is always a point someone can make, which can be material to sentence. I do rely on the fact that the authors of Arledge describe Italy as doubtful, and they do so with good reasons. And my lord, my lady, you can look at those reasons in due course. I don't propose to delay the court by dwelling on them. The authors of Grant go a bit further and use slightly stronger language and describe Italy as heretical. That's not language I would use particularly here, but I do say that it should be confined to its own facts, because it's inimical to the proper administration of justice and the rule of law. I also would like to adopt, particularly because I didn't think of it myself, my Lord Justice Lewison's point that the rules are consistent with my case. The rules in Part 81. And I would invite the court to adopt the statement of the law in Sir Christopher Clark's judgment in Masri, and that's at paragraphs 150 to 155, for the reasons that he gives therein, and also the policy reasons that I have expressed, the additional policy reasons. It would be useful in my respectful submission if the court could positively state that Italy should not be treated as an authority for the proposition that intention to disobey was a requisite part of the test. the reason I say it would be useful is because, as my learned friend very properly draws to the court's attention, there are conflicting authorities at Court of Appeal level.
Are there authorities at Court of Appeal level which follow Telly? Don't think we were shown any.
No, there aren't.
So Telly in this respect is an outlier.
Yes, it's described as, I noticed in one of the judgments, it's described as one line of 2 lines of authorities.
Now that's Mr. Justice Jacob.
Yes, it's more of a dot in my submission.
Right.
Forthwith, this is the part of the judgment which is found at paragraphs 137 to 142.
Yeah.
Mr. Leonard Skeleton complains that the judge didn't engage with the meaning of forthwith. He also didn't engage with the meaning of authority, or letter, or sign. Forthwith is an ordinary word. I don't see that it amounts to a point that can be taken before this court if it wasn't argued below by the appellant. No criticism of my learned friend, of course. Forthwith means as soon as reasonably practicable. To the extent that it was needed, I've included a judgment on that. You'll have seen in my skeleton argument that I draw attention to other time periods that are given for compliance with orders in certain circumstances. So 14 days, for example. 2 really pertinent examples in this context are the time that someone is given to respond informally to an asset disclosure order under a freezing injunction, which is normally 48 hours. Then they're given 7 days or 5 days. There's a slight difference of practice between the Commercial Court and the Chancery Division as to how much time they're given to provide an affidavit formally confirming what information they have given already informally. I don't say that forthwith in all circumstances means in less time than 48 hours. It means as soon as reasonably practicable, and that's circumstance dependent. I'm criticised for not cross-examining on the circumstances. Well, no circumstances were put forward which could possibly have excused the delay in providing the signed letter.
Well, you had direct evidence that he had delayed doing it while he pressed for the quid pro quo of getting his passport back.
Yes, exactly. And if the court would like the relevant reference in Mr. Gray's affidavit, was it paragraph 86?
I think we've got it. Or at least we've got the reference.
We've seen it in Mr. Gray's evidence.
Oh, excellent. Well, I can tell you that it was provided on the 2nd of August and before noon, so the very day after the order.
Right.
So there was no delay in us doing what we had to do to enable that to do forthwith. My learned friend is wrong to say that he didn't confirm that he was in breach. He did confirm that he was in breach because he said, I've complied with all the conditions of the order. Pausing there, that was wrong because he didn't do it forthwith. Then he goes on to say, except signing. But it was part of the order that he had to provide the signed authority, without which signature it would be useless. So, as far as I was concerned, well, let me put it this way, so that I don't stray into privilege. The joint liquidators case couldn't get any better by me cross-examining. Indeed, it would have been incompetent for me to do so, because I would have exposed the joint liquidators to a risk of not establishing a breach which was established by Mr. Varma's own evidence. I also have a responsibility when I'm cross-examining as to the joint liquidators in instructing me where committal proceedings are advanced to the administration of justice because of everyone's interest in orders being complied with. So it would have been a pointless risk to my client for me to open my mouth and give Mr. Varma a platform to explain why he hadn't done what he'd been told to do, because you've already seen he was trying to impose conditions that weren't in the order on his compliance, which is wholly illegitimate.
Now, Mr. Brown, you're going to have to wrap up your submission soon in order to give Mr. McCormick time for a reply.
There's only one paragraph I have no further submissions, save for this.
Right.
Is this on forthwith still?
No, I'm
There's a
leaving
new
forthwith
point.
and I'm just going to a sort of general point here. The page reference is tab 8, page 63, and I'd invite the court to read paragraph 164, and I'll make a short submission.
Litigation may well ensue.
It is a construction lawyer.
Having drawn your lordship's attention to that paragraph, this goes to intention. And if one flips over the page and refreshes one's memory of the contempts, it was the joint liquidators case that all of these contempts had two aims. One, hiding Mr. Varma's own wealth, and two, hiding what he had done with the money he had misappropriated from the company, and indeed contesting that he had misappropriated that money. And all of those contempts, and the impression that the judge had from hearing from Mr. Varma over 3 days of Mr. Varma's evidence, and hearing a trial that lasted 4 days, from all the documentary evidence, was that we were right about that. It was his intention to hide his own wealth and to frustrate these proceedings. And I hope the court doesn't mind me making the point that whilst Mr. Varma's interests are very important, the court has to consider on an appeal from a contempt, a judgment making findings of contempt, the interests of the victim. The proximate victim is the company, but of course behind the company are the creditors who invested money in the hotel. It also has to consider other court users, and that's a matter of supreme importance because we're concerned here with the administration of justice. Unless I can assist further, those are my submissions.
Anything more? Thank you very much, Mr.
Thank you very much.
Yes, Mr. McCormick, any reply?
My lord, yes. Short. I'll deal with topic by topic. Disclosure. The type of order that would have been made had an application been made, it is actually looking at this from the wrong way round. But in order to humour a learned friend, the order would be precisely the sort of order made by Mr. Justice Tier in Appellant, which was, you will disclose all documents which are adverse to your own case or which favour the case of the person you're trying to commit to prison for contempt. That was the order Mr. Justice Tier made, and it's perfectly properly made. I did note that my friend didn't take or engage with the underlying ethos set out by Mr. Justice Tier of the basic fairness of someone who's trying to commit someone to prison for contempt, disclosing what they've got, which might actually be unknown to the person they're pursuing, and which might help to exonerate them.
What about in a case like this where all the material is available to the person anyway?
Well, my lord, it wasn't. This is the point. What I had a note from Mr. Shipley, and I accepted that the material that was sent on the 10th of June also went up on the CE filing system on that at that same time. Assuming, therefore, that if Mr. Leonard or my instructing solicitor's predecessors had, in the midst of the committal hearing, bothered to check the CE filing system, although there's no reason why they would have done so, they would have been able to see it. They look sceptically at me when I make that submission. But as he's made clear, these weren't statements provided against a deadline which was known to anybody else. These are statements which come late. When I, in fact, used the hard deadline, I meant the deadline of the trial, not any direction. So what we've got is witness statements coming in very shortly before the trial on the 10th of June, going to the liquidators, also going up on the CE filing system. Now, the liquidators doubtless saw them as they went in. So they were aware of them. But to assume that my client's legal representatives were also keeping an eye on the CE filing system for the linked trial in the hope, macabre-ish, that something would turn up, when they'd no particular reason to believe it would, that's an unequal balance. If they took the view that, well, they're on the CE filing system for everyone to see, all they had to do was send an email saying, you might like to check the CE filing system. So I say, especially bearing in mind that these documents came in during the committal trial, it is unrealistic to say that because they were on CE filing system, that means they were available to my client, or they couldn't be taken to have been available to him. And in any event, if one's considering the concept of fairness with officers of the court bringing the contempt proceedings, my learned friend repeatedly said, where's the duty on it? To which the answer is, there's a duty of fairness and dispassionate prosecution of these matters, letting facts speak for themselves. Mr. Justice Tier, Mr. Justice Andrew Baker. That is the duty that applies here.
And the test giving rise, for which you're contending, is that they are adverse or that they are potentially material?
Well, in this case, I say they're no adverse documents.
No. Well, what's the test?
Well, they will assist the contemnor or the alleged contemnor in resisting the application.
And that's the touchstone that you say should apply to your duty.
To their duty.
To the duty for which you're contending.
Yes, indeed. And my learned friend says it's disproportionate. In my submission, it's not disproportionate to impose that duty, because that duty is but one feature of the duty that Mr. Justice Andrew Baker or Mr. Justice Tier took pretty much as given if you're going to try and commit someone to prison for contempt. And I appreciate entirely that in the context of this particular case, one says, well, maybe it's on CE filing system. Maybe my client isn't the most sympathetic person to rely on that duty. But whatever duty your lordships, your ladyship, may be inclined to decide exists or doesn't exist, will apply to all persons who are facing applications to commit them to prison for contempt by liquidators, officers of the court, represented by solicitors of counsel. And what my friend's submission really comes to is this: they can have whatever document they like in their files, however damaging to their own case, however helpful to the contemnor, but unless the contemnor actually makes an application for disclosure, they are perfectly entitled to sit there with the document and not reveal it to the judge who is asked to commit that person to prison. Now, that is a submission which I have to confess, I did find slightly surprising. There's no hint of the submission on the other side that there's any obligation whatsoever. And I will take on the chin that the disclosure pilot does not apply. This is not a case which would be decided on whether or not there is a formal rule that says you have to disclose.
Yeah, no, I think we've
you have my point
yeah.
on that. And in relation to whether or not there are inconsistencies between the two judgments, can I ask your lordships to look at my learned friend's skeleton argument in the core bundle at tab 6? Because I was surprised to hear him say that I think there wasn't an inconsistency, or if there was an inconsistency, it was only restricted to the existence of the jewellery. And it should be page 12.51. It's internal page 11 of my friend's skeleton argument.
So it is paragraph 28.
No, it's not. I'm sorry. It's paragraph 41 of Malone Friends Skeleton Argument in the core bundle.
I think that's
Core
what
bundle tab 6.
Yeah, paragraph 41, you see.
Yes, that should be a heading.
Yes,
for
yes, yes, got it.
So, last sentence of that paragraph. This is wrong both as a matter of principle and practice, considering the specific inconsistency between the judgments. Now, we don't need 42. Over the page of 43, there is one question which the learned judges reached opposite conclusions. Whether the diamonds and jewellery said to have been given by the appellant to GCFZE was then sold to the company in exchange for £3.12 million. His Honour Judge Johns found there had been no sale. ICC Judge Prentice found the company did in fact receive diamonds and jewellery. Difference between those conclusions is that of ICJ Prentice not. So, the respondent's case before your lordship is in fact that His Honour Judge Prentice, ICC Judge Prentice, did in fact reach that conclusion. And again, it's at paragraph 49 on the following page. Because it's there argued it simply wasn't open as a matter of law for Judge Prentice to hold that the diamonds and jewellery existed and were paid to the company. So that's the position. And as I hope I made clear, and I believe from remarks made to a friend in argument, it's not merely the fact of the inconsistency, it's what that imports for the fairness of continuing to have my client at risk of being imprisoned on the basis of the inconsistencies of the judgments.
Could you, for my benefit, if no one else has, identify where you say that Judge Prentice found that the jewellery was given to the company?
Lord, it's in Supplemental Bundle 2, tab 28. And if I take your lordship, first of all, to the paragraphs my learned friend cites in this skeleton argument, it's paragraphs 201 to 206.
Thank you.
There's 201 to 206 is where what my friend, I think it must be 205, that he cites as the basis for the.
This is D505.
It is D504 to 505, maybe, yes. My lord, it's not expressly set out there in the judgment. I accept that. What I took my friend to be saying was, this is implicit because the £2 million comes out of the 3.1 million, and therefore the only sensible basis to approach ICJ Prentice's decision is that there was the 3.1 million paid, out of which the 2 million was forwarded to the son.
It doesn't say that.
Well,
is there anywhere else you want to go to sustain the or to endorse the proposition that the company did in fact receive diamonds and jewellery?
Look, on my way to my next reference, my friends asked that I direct the court to paragraph 214 at page 508.
Thank you.
And then beyond that, it will be paragraphs 221 to 226. And then beyond that one then circles back to 227 onwards to the evidence about the wealth of the grandparents, and by the evidence of the fourth respondent, Mr. Varma Jr., and then his mother, 232 through to 235. But if your Lordship is asking me, and I think your Lordship is there a sentence in the judgment that says the jewellery was passed and 3.1 million was paid over? The answer is no. But that is clearly the sense of the judgment in terms of the 2 million, because that's the way it's represented in the Respondent's skeleton argument.
Well, is that right? I mean, the sense that I get out of this section of judgment is that Grandma gave the jewels to Father. Father sold them and paid 2 million to Son. Nothing to do with the company. That's what I take from that section of the judgment.
Well, my Lord, I must confess, I've been working on the basis that the Respondent's skeleton argument, which says, in terms, that ICCJ Prentice made that decision, reflects the better insight of the advocates who were there and were in the cut and thrust of the case. That's
all right.
That's all I can say on that point. The factual submissions made on findings 3 and 4 about intent are irrelevant because the judge decided he wasn't satisfied that there was an intent to breach the order. So I'm not quite sure what place they have to play in the appeal. As to whether or not needing to prove intent defines the contempt jurisdiction, in my submission it clearly won't. And my learned friend put up the vista of convenient lawyers who will give unwise advice on imperfect information. Well, the courts are well able to sort that sort of chaff from the wheat. It's an interorum plea which in my submission has no attraction whatsoever. Lord, in relation to whether or not the evidence about the jewellery in fact bears at all on finding 1, I hope that in my opening address to the court, I made clear that I accepted that proof that the jewellery existed was by no means a guarantee that finding 1 would fall, but it is a fundamental point. It goes to credibility. And the arguments can be had about whether or not the better witness was my client who had seen the jewellery or other witnesses who did not see it, but who heard things said and spoke to people about it many years ago. It's clearly better if they're all giving evidence. And the question was asked, what's going to happen if the matter is remitted? Will these people give evidence bearing in mind the family rift? Well, the colloquial answer from the advocate standing before you is, if it's anything to do with us, they will. Whether or not we'll be able to get them into a courtroom by means of a summons if necessary, I simply don't know. But if we can't, we've got pretty good material for a hearsay notice, because we've got the transcripts of their evidence under extremely competent cross-examination. And we know that the last time that happened, they were believed. In my submission, that's not a bad starting. Unless there's anything else your Lordship or your Ladyship want.
Thank you very much, Mr. McCormick.
Thank you, Lord.
Well, thank you both very much for your interesting submissions. Clearly there's a lot to think about, so we will reserve our judgments. You will get drafts in the usual way. It will be your opportunity to correct our spelling and grammar, but not our reasoning or to re-argue the case. In the light of the draft judgments, we would hope that you would be able to agree an order disposing of the appeal. If you can't agree the form of order, please make submissions on it in writing. I'm afraid it looks likely that the hand-down is still going to be a remote hand-down due to current restrictions, but even if it's a live hand-down in court, there will be no need for any attendance. Thank you very much.
Court rise.
Yes.
And every time I read it, I think it says something else.
Well, isn't that the attraction of a good book? I learn it every time you go to read it.
Well, it had a surprise ending. Would you mind stepping out and calling Ben to come give us a hand? Try to make sure we don't lose Piers this time.
What I'm going to do is. Yeah, no, by all means, by all means.
And then we also go meet another time.
Great. I've got to see if I can win the floor. Do you know my chamber's phone number?
Let's bring it down. You normally have underlings.
All right. Okay, of course.
The little man who knows your phone. He's 27409.
It's I know my own number. I just don't know the phone number. Where's the mask? Where's my mask? Here it is. Darren! I was just saying, I don't know the phone number of chambers. Right, okay. So there we go.
I'll see you after 5 minutes.
Oh, right, okay, I'll do that in a second. Are you going to go take all of that?
I'm going to meet Dan anyway.
Yeah, no, that's fine. Okay. I've got a conference. No. Project, did you hear about that? No, it's Thursday. And we're going to have available. Do that. What is it time?
A4. Extend our reach.
Yeah, fine. Good to see you too.
Well, actually, it's lovely. Yeah, well done. Good luck. And I'll be in touch.
You don't say good luck, you know what you mean. Yeah. Okay.
They still going?
I'll just wait for that.
All right, buddy.
I'll already talk with you.
No, can't. One talking to
Well.
televised audience of 3s or 4s.
Yes, all right. I'll speak to Cartridge because he's come back to go. I'll speak to you.
Yeah. Yeah, I really got opportunities today. I'm quite happy for a remote hearing. You know, no desk to put my all Piers was the same. So, yeah, okay, that was a couple of minutes ago. Thank you. Cheers. Bye. I'll hear it. Naughty notice from Ed. That's, he's ringing them, so.
So if I wave, will David see me?
In about 5 minutes' time.
If I do another gesture?
And the whole world will see you in forever. As that, just
Thank you very much. Have a good evening. Cheerio.
seen Sheila?
I've not seen her now.
Or Fiona, no? You haven't seen me. Or Fiona?
No.
Oh, hi, it's Lucy.